Section 8 of Indian Evidence Act. Motive, preparation and previous or subsequent conduct. Illustration. It is well settled law that where the direct evidence regarding the assault is worthy of the credence and can be believed, the question of motive becomes more or less academic. Sometimes the motive is clear and can be proved, and sometimes the motive is shrouded in the mystery and it is very difficult to locate the same. If, however, the evidence of eyewitnesses is creditworthy and is believed by the court, which has placed implicit reliance on them, the question whether there is any motive or not becomes wholly irrelevant. Section 9 of Indian Evidence Act. Facts necessary to explain or introduce relevant facts. Test identification period. Facts necessary to explain or introduce a fact in issue are relevant fact or which support or rebut an inference suggested by a fact in issue or relevant fact or which establish the identity of anything, a person whose identity is relevant or fix the time or place at which any fact in issue or relevant fact happened or which show the relation of parties by whom any such fact was transacted are relevant insofar as they are necessary for that purpose. Illustrations. The question is whether a given document is the will of A. The state of A's property and of his family at the date of the alleged will may be relevant facts. Section 10. Things said or done by conspirator in reference to common design. Where there is reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such persons in reference to their common intention after the time when such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to so conspiring as well for the purpose of proving the existence of the conspiracy as for the purpose of showing that any such person was a party to it. Section 11. When facts not otherwise relevant become relevant. Facts not otherwise relevant or relevant. If they are inconsistent with any fact in issue or relevant fact, if by themselves or in connection with other facts they make the existence or non existence of any fact in issue or relevant fact highly probable or improbable. Damages. Facts tending to enable court to determine amount are relevant. In suits in which damages are claimed, any fact which will enable the court to determine the amount of damages which ought to be awarded is relevant. Section 13. Facts relevant when right or custom is in question. Where the question is as to the existence of any right or custom, the following facts are relevant. Any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted, or denied, or which was inconsistent with its existence. Particular instances in which the right or custom was claimed, recognized, or exercised, or in which its exercise was disputed, asserted, or departed from. Section 14. Facts showing existence of state of mind or of body or bodily feeling. Facts showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will, or good will towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or body or bodily feeling is an issue or relevant. Explanation 1. A fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to the particular matter in question. Explanation 2. But where, upon the trial of a person accused of an offence, the previous commission by the accused of an offence is relevant within the meaning of this section, the previous conviction of such person shall also be a relevant fact. Section 15. Facts bearing on question whether act was accidental or intentional. When there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. Section 16. Existence of course of business when relevant. When there is a question whether a particular act was done, the existence of any course of business according to which it naturally would have been done is a relevant fact. Section 17. Admission defined. An admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. Section 18. Admission by party to proceeding or his agent. Statements made by a party to the proceeding or by an agent to any such party whom the court regards under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. By suitor in representative character. Statements made by parties to suits suing are sued in a representative character are not admissions unless they were made while the party making them held that character. Statements made by one party interested in subject matter. Persons who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character of persons so interested, or 2. Person from whom interest derived. Persons from whom the parties to the suit have derived their interest in the subject matter of the suit, or admissions if they are made during the continuance of the interest of the persons making the statements. Section 19. Admissions by persons whose position must be proved as against party to suit. Statements made by persons whose position or liability it is necessary to prove as against any party to the suit, or admissions, if such statements would be relevant as against such persons in relation to such position or liability in a suit brought by or against them, and if they are made whilst the person making them occupies such position or is subject to such liability. Section 20. Admissions by persons expressly referred to by party to suit. Statements made by persons to whom a party to the suit has expressly referred for information in reference to a matter in dispute, or admissions. Section 21. Proof of admissions against persons making them by or on their behalf. Admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest, except in the following cases. 1. An admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead, it would be relevant as between third persons under section 32. 2. An admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body relevant or an issue made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. 3. An admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. Section 22. When oral admissions as to contents of documents are relevant, oral admissions as to the contents of a document are not relevant unless and until the party are proposing to prove them shows that he is entitled to give secondary evidence of the contents of such document under the rules hereinafter contained or unless the genuineness of a document produced is in question. Section 22A. When oral admissions as to contents of electronic records are relevant, oral admissions as to the contents of electronic records are not relevant unless the genuineness of the electronic record produced is in question. Section 23. Admissions in civil cases when relevant. In civil cases, no admission is relevant if it is made either upon an express condition that evidence of it is not to be given or under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. Explanation. Nothing in this section shall be taken to exempt any barrister, pleader, attorney, or vakil from giving evidence of any matter of which he may be compelled to give evidence under Section 126. Confessions. Section 24. Confession caused by inducement, threat, or promise when irrelevant in criminal proceeding. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, or promise having reference to the charge against the accused person proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. Section 25. Confession to police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offense. Section 26. Confession by accused while in custody of police not to be proved against him. No confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Explanation. In this section, magistrate does not include the head of a village discharging magisterial functions in the presidency of Fort St. George or elsewhere, unless such head man is a magistrate exercising the powers of a magistrate under the Code of Criminal Procedure. Section 27. How much of information received from accused may be proved, provided that when any fact is disposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. Section 28. Confession made after removal of impression caused by inducement, threat, or promise relevant. If such a confession as is referred to in section 24 is made after the impression caused by any such inducement, threat, or promise has, in the opinion of the court, been fully removed, it is relevant. Section 29. Confession otherwise relevant not to become irrelevant because of promise of secrecy, etc. If such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such confession and that evidence of it might be given against him. Section 30. Consideration of proved confession affecting person making it and others jointly under trial for same offense. When more persons than one are being tried jointly for the same offense and a confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. Explanation. Offense as used in this section includes the abatement of or attempt to commit the offense. Section 31. Admissions not conclusive proof but may stop. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions hereinafter contained. Statements by persons who cannot be called as witnesses. Section 32. Cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. Statements written or verbal of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which, under the circumstances of the case, appears to the court unreasonable or themselves relevant facts in the following cases. 1. When it relates to cause of death. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. 2. Or is made in course of business. When the statement was made by such person in the ordinary course of business, and in particular when it consists of any entry or memorandum made by him in books kept in the ordinary course of business, or in the discharge of professional duty, or of an acknowledgement written or signed by him of the receipt of money, goods, securities, or property of any kind, or of a document used in commerce written or signed by him, or of the date of a letter or other document usually dated, written, or signed by him. 3. Or against interest of maker. When the statement is against the pecuniary or proprietary interest of the person making it, or when, if true, it would expose him or would have exposed him to a criminal prosecution or to a suit for damages. 4. Argues opinion as to public right or custom or matters of general interest. When the statement gives the opinion of any such person as to the existence of any public right or custom or matter of public or general interest, of the existence of which, if it existed, he would have been likely to be aware, and when such statement was made before any controversy as to such right, custom, or matter had arisen. 5. Or relates to existence of relationship. When the statement relates to the existence of any relationship by blood, marriage, or adoption between persons as to whose relationship by blood, marriage, or adoption the person making the statement had special means of knowledge, and when the statement was made before the question in dispute was raised. 6. Or is made in will or deed relating to family affairs. When the statement relates to the existence of any relationship by blood, marriage, or adoption between persons deceased and is made in any will or deed relating to the affairs of the family to which any such deceased person belonged, or in any family pedigree, or upon any tombstone, family portrait, or other thing on which such statements are usually made, and when such statement was made before the question in dispute was raised. 7. Or in document relating to transaction mentioned in section 13, class A. When the statement is contained in any deed, will, or other document which relates to any such transaction as is mentioned in section 13, class A. 8. Or is made by several persons and expresses feelings relevant to matter in question. When the statement was made by a number of persons and expressed feelings or impressions on their part relevant to the matter in question. Section 33. Relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the facts which it states when the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party or if his presence cannot be obtained without an amount of delay or expense which, under the circumstances of the case, the court considers unreasonable, provided that the proceeding was between the same parties or their representatives in interest, that the adverse party in the first proceeding had the right and opportunity to cross examine, that the questions in issue were substantially the same in the first as in the second proceeding. Explanation. A criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. Section 34. Statements made under special circumstances. Entries in books of account, including those maintained in an electronic form when relevant. Entries in books of account, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever they refer to a matter into which the court has to inquire, but such statements shall not alone be sufficient evidence to charge any person with liability. Section 35. Relevancy of entry in public record or an electronic record made in performance of duty. An entry in any public or other official book, register, or record or an electronic record stating a fact in issue or relevant fact and made by a public servant in the discharge of his official duty or by any other person in performance of a duty specifically enjoined by the law of the country in which such book, register, or record or an electronic record is kept is itself a relevant fact. This read together with section 79. Section 36. Relevancy of statements in maps, charts, and plans. Statements of facts in issue are relevant facts made in published maps or charts generally offered for public sale or in maps or plans made under the authority of the central government or any state government as to matters usually represented as stated in such maps, charts, or plans are themselves relevant facts. Section 37. Relevancy of statement as to fact of public nature contained in certain acts and notifications. When the court has to form an opinion as to the existence of any fact of a public nature, Any statement of it made in a reciter contained in any Act of Parliament of the United Kingdom or in any Central Act, Provincial Act, or a State Act, or in a government notification or notification by the Crown representative appearing in the official gazette or in any printed paper purporting to be the London Gazette or the government gazette of any dominion, colony, or possession of His Majesty is a relevant fact. Section 38. Relevancy of statements as to any law contained in law books. When the court has to form an opinion as to a law of any country, any statement of such law contained in a book purporting to be printed or published under the authority of the government of such country and to contain any such law and any report of a ruling of the courts of such country contained in a book purporting to be a report of such rulings is relevant. Section 39. How much of a statement is to be proved? What evidence to be given when statement forms part of a conversation, document, electronic record, book, or series of letters or papers? When any statement of which evidence is given forms part of a longer statement or of a conversation or part of an isolated document or is contained in a document which forms part of a book or is contained in part of electronic record or of a connected series of letters or papers, evidence should be given of so much and no more of the statement, conversation, document, electronic record, book, or series of letters or papers as the court considers necessary in that particular case to the full understanding of the nature and effect of the statement and of the circumstances under which it was made. Section 40. Judgment of courts of justice when relevant. Previous judgments relevant to bar a second suit or trial. The existence of any judgment, order, or decree which by law prevents any courts from taking cognizance of a suit or holding a trial is a relevant fact when the question is whether such court ought to take cognizance of such suit or to hold such trial. Section 41. Relevancy of certain judgments in probate, etc. jurisdiction. A final judgment, order, or decree of a competent court in the exercise of probate, matrimonial, admiralty, or insolvency jurisdiction which confers upon or takes away from any person any legal character or which declares any person to be entitled to any such character or to be entitled to any specific thing, not as against any specified person but absolutely, is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. Such judgment, order, decree is conclusive proof. Judgment in rem. That any legal character which it confers accrued at the time when such judgment, order, or decree came into operation, that any legal character to which it declares any such person to be entitled accrued to that person at the time when such judgment, order, or decree declares it to have accrued to that person. That any legal character which it takes away from any such person seized at the time from which such judgment, order, or decree declared that it has ceased or should cease, and that anything to which it declares any person to be so entitled was the property of that person at the time from which such judgment, order, or decree declares that it had been or should be his property. Section 42. Relevancy and effect of judgments, orders, or decrees other than those mentioned in Section 41. Judgments, orders, or decrees other than those mentioned in Section 41 are relevant if they relate to matters of a public nature, relevant to the inquiry, but such judgments, orders, or decrees are not conclusive proof of that which they state. Section 43. Judgments, etc., other than those mentioned in sections 40 to 42. When relevant, judgments, orders, or decrees other than those mentioned in sections 40, 41, and 42 are relevant unless the existence of such judgment, order, or decree is a fact in issue or is relevant under some other provisions of this Act. Section 44. Fraud or collusion in obtaining judgment or incompetency of court may be proved. Any party to a suit or other proceeding may show that any judgment, order, or decree which is relevant under Section 40, 41, or 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion. Section 45. Opinions of third person when relevant. Opinions of experts. When the court has to form an opinion upon a point of foreign law or science or art or as to identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, science or art or in questions as to identity of handwriting or finger impressions are relevant facts. Such persons are called experts. Section 45A. Opinion of examiner of electronic evidence. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in Section 79A of the Information Technology Act is a relevant fact. Explanation. For the purposes of this section, an examiner of electronic evidence shall be an expert. Section 46. Facts bearing upon opinions of experts. Facts not otherwise relevant or relevant if they support or are inconsistent with the opinions of experts when such opinions are relevant. Section 47. Opinion as to handwriting when relevant. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed that it was or was not written or signed by that person is a relevant fact. Explanation. A person is said to be acquainted with the handwriting of another person when he has seen that person write or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to him. Section 47A. Opinion as to electronic signature when relevant. When the court has to form an opinion as to the electronic signature of any person, the opinion of the certified authority which has issued the electronic signature certificate is a relevant fact. Section 48. Opinion as to existence of right or custom when relevant. When the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would be likely to know of its existence if it existed are relevant. Explanation. The expression general custom or right includes customs or rights common to any considerable class of persons. Section 49. Opinions as to usages, tenets, etc. when relevant. When the court has to form an opinion as to the usages and tenets of any body of men or family, the constitution and government of any religious or charitable foundation, or the meaning of words or terms used in particular districts or by particular classes of people, the opinions of persons having special means of knowledge thereon are relevant facts. Section 50. Opinion on relationship when relevant. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such a relationship or any person who, as a member of the family or otherwise, as special means of knowledge on the subject is a relevant fact, provided that such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act or in prosecution under sections 494, 495, 497 or 498 of the Indian Penal Code. Grounds of opinion, section 51. Grounds of opinion when relevant. Whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. Section 52 of Indian Evidence Act. In civil cases, character to prove conduct imputed irrelevant. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant except in so far as such character appears from facts otherwise relevant. Section 53. In criminal cases, previous good character relevant. In criminal proceedings, the fact that the person accused of a good character is relevant. Section 54. Previous bad character not relevant except in reply. In criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. Explanation 1. This section does not apply to cases in which the bad character of any person is itself a fact in issue. Explanation 2. A previous conviction is relevant as evidence of bad character. Section 55. Character as affecting damages. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Explanation. In sections 52, 53, 54, and 55, the word character includes both reputation and disposition, but except as provided in section 54, evidence may be given only of general reputation and general disposition and not of particular acts by which reputation or disposition were shown. Part 2 on Proof, Chapter 3. Facts which need not be proved. Section 56. Fact judicially noticeable need not be proved. No fact of which the court will take judicial notice need not be proved. Section 57. Facts of which court must take judicial notice. The court shall take judicial notice of the following facts. 1. All laws in force in the territory of India. 2. All public acts passed or hereafter to be passed by the Parliament of the United Kingdom and all local and personal acts directed by Parliament of the United Kingdom to be judicially noted. 3. Articles of war for the Indian Army, Navy or Air Force. 4. The course of proceeding of Parliament of the United Kingdom, of the Constituent Assembly of India, of Parliament and of the legislatures established under any law for the time being in force in a province or in the state. 5. The accession and the signed manual of the sovereign for the time being of the United Kingdom of Great Britain and Ireland. 6. All seals of which English courts take judicial notice, the seals of all the courts in India and all courts out of India are established by the authority of the central government or the crown representative, the seals of courts of admiralty and maritime jurisdiction and of notaries public, and all seals which any person is authorized to use by the Constitution or an Act of Parliament of the United Kingdom or an Act or regulation having the force of law in India. 7. The accession to office, names, titles, functions, and signatures of the persons filling for the time being any public office in any state, if the fact of their appointment to such office is notified in any official gazette. 8. The existence, title, and national flag of every state or sovereign recognized by the Government of India. 9. The divisions of time, the choreographical divisions of the world and public festivals
fast and holidays notified in the official gazette. 10. The territories under the dominion of the Government of India. 11. The commencement, continuance, and termination of hostilities between the Government of India and any other state or body of persons. 12. The names of the members and officers of the court and of their deputies and subordinate officers and assistants and also of all officers acting in execution of its powers and of all advocates, attorneys, proctors, workers, pleaders, and other persons authorized by law to appear or act before it. 13. The rule of the road on land or at sea. In all these cases and also on all matters of public history, literature, science, or art, the court may resort for its aid to appropriate books or documents of reference. If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so. Section 58. Facts admitted need not be proved. No fact need to be proved in any proceeding. If the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admissions. Chapter 4 of Oral Evidence. Section 59. Proof of facts by oral evidence. All facts except the contents of documents or electronic records may be proved by oral evidence. Section 60. Oral evidence must be direct. Oral evidence must, in all cases, whatever be direct, that is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. If it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. If it refers to an opinion or to the grounds on which that person is held, it must be the evidence of the person who holds that opinion on those grounds, provided that the opinions of experts expressed in any treatise commonly offered for sale and the grounds on which such opinions are held may be proved by the production of such treatise. If the author is dead or cannot be found or has become incapable of giving evidence or cannot be called as a witness without an amount of delay or expense which the court regards as unreasonable, provided also that if oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. Chapter 5 of Documentary Evidence. Section 61. Proof of contents of documents. The contents of documents may be proved either by primary or by secondary evidence. Section 62. Primary evidence. Primary evidence means the document itself produced for the inspection of the court. Explanation 1. Where a document is executed in several parts, each part is primary evidence of the document. Where a document is executed in counterpart, each counterpart being executed by one or some of the parties only, each counterpart is primary evidence as against the parties executing it. Explanation 2. Where a number of documents are all made by one uniform process, as in the case of printing, lithography, or photography, each is primary evidence of the contents of the rest. But where they are all copies of a common original, they are not primary evidence of the contents of the original. Section 63. Secondary evidence. Secondary evidence means and includes 1. Certified copies given under the provisions hereinafter contained. 2. Copies made from the original by mechanical processes which in themselves ensure the accuracy of the copy. and copies compared with such copies. 3. Copies made from or compared with the original. 4. Counterparts of documents as against the parties who did not execute them. 5. Oral accounts of the contents of a document given by some person who has himself seen it. Section 64. Proof of documents by primary evidence. Documents must be proved by primary evidence except in the cases hereinafter mentioned. Section 65. Cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents of a document in the following cases. A. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or of any person out of reach of or not subject to the process of the court, or of any person legally bound to produce it, and when, after the notice mentioned in section 66, such person does not produce it. B. When the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. C. When the original has been destroyed or lost, when the party offering evidence of its contents cannot, for any other reason not arising from his own default or neglect, produce it in reasonable time. D. When the version is of such a nature as not to be easily movable. E. When the version is a public document within the meaning of section 74. F. When the original is a document of which a certified copy is permitted by this Act or by any other law in force in India to be given in evidence. G. When the originals consist of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole collection. In cases A, C, and D, any secondary evidence of the contents of the document is admissible. In case B, the written admission is admissible. In case E or F, a certified copy of the document but no other kind of secondary evidence is admissible. In case G, evidence may be given as to the general result of the documents by any person who has examined them and who is skilled in the examination of such a document. 65A. Special provisions as to evidence relating to electronic record. The contents of electronic records may be proved in accordance with the provisions of Section 65B. Section 65B. Admissibility of electronic records. 1. Notwithstanding anything contained in this Act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, hereinafter referred to as the computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original as evidence of any contents of the original or of any fact stated therein of which direct evidence would be admissible. 2. The conditions referred to in subsection 1 in respect of a computer output should be the following, namely A. The computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period by the person having lawful control over the use of the computer. B. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. C. Throughout the material part of the said period, the computer was operating properly or If not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period was not such as to affect the electronic record or the accuracy of its contents, and D. The information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activities. 3. Where over any period the function of storing or processing information for the purposes of any activities regularly carried on over that period as mentioned in class A of subsection 2 was regularly performed by computers, whether by a combination of computers operating over that period or by different computers operating in succession over that period or by different combinations of computers operating in succession over that period or in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combinations of computers, all the computers used for that purpose during that period should be treated for the purposes of this section as constituting a single computer, and references in this section to a computer should be construed accordingly. 4. In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, A. Identifying the electronic record containing the statement and describing the manner in which it was produced. B. Giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. C. Dealing with any of the matters to which the conditions mentioned in subsection 2 relate and purporting to be signed by a person occupying a reasonable official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purposes of this subsection, it shall be sufficient for a major matter to be stated to the best of the knowledge and belief of the person stating it. For the purposes of this section, information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, and whether it is so supplied directly or with or without human intervention by means or any appropriate equipment.